the topic for today is EB-1, EB-2, and EB-3 green cards for people who are interested in employment-based immigration. We have a lot of people who registered, and actually you guys submitted some really good questions to me, so I'm excited to get right into it. So let me just get right into starting with EB-1. I had a number of people ask questions about EB-1, but actually even before I do that, I just want to give everybody an understanding about what the general employment-based process in the United States is like. So most of you are here because you understand a little bit of something about visas, or maybe you have questions about visas and you want to go straight into the green card context. But many of you have already understood the idea of getting some kind of a visa, work-based visa. And now you're looking at the next step, which is the green card application. And the general theme about green card applications in the United States is that they are sponsored by an employer. Okay, these are employment-based green cards. So they're sponsored by an employer. So typically, an employee or a person cannot individually without an employer apply for a green card. Now, there are some notable exceptions to this. One of them is a green card called an EB-1A, and another one is an application for EB-2 with a national interest waiver. Okay, so we'll get into the EB-1A first. EB-1A is a green card for persons of extraordinary ability. What does that mean? That means that somebody who has, proven that they have ability beyond the average ability of the persons in their field is eligible to apply for a green card under the EB-1 category. And there are three EB-1 categories. The first one is this EB-1A that I'm referring to today. Then the other thing that's important to note about EB-1As is that it's a two-part test. The first part is getting 3 specific criteria out of 10. Now, if you want to know what these specific criteria are, the 10 specific points out of which you have to prove 3, you can look that up on USCIS, and we can send you a link about that later. I don't want to read each and every point here because out of respect for time. But basically, there's 10 specific points, and I'll give you an example of a couple of them. One is somebody who is receiving higher than normal remuneration for their field, right? So if you are somebody who's, say you're an electrical engineer, you have 6 years of experience, but your salary is beyond somebody else who is also an electrical engineer with 6 years of experience. So there's 2 tests with EB-1A. One is the 3 categories out of 10, right? An example I gave of one of those 10 categories was the amount that somebody is being compensated for their work in comparison to other people with the same level of experience and in that field as well. So if you're an electrical engineer with 6 years of experience and your compensation is we'll just say 150,000. But most people with 6 years of experience with electrical engineers say they make an average of 85,000. I don't know if these numbers are accurate, so please don't focus on the numbers. But the point being that the fact that you can show that your compensation is significantly above others who are in that same field with the same level of experience, that is one of the criteria that you can prove, right? So this is an example of how you can meet 3 out of 10, right? This is one. And there are others. There's some that say, have you authored original work? So if you're, somebody who's in a field where you are involved in research and you've done a thesis statement for your PhD, or you've done, you know, original work of authorship. That is another criteria. There's 10. So again, I don't want to go into each and every one in the interest of time, but there's 10, and you have to meet a minimum of 3 to the satisfaction of USCIS. Okay, that's the first test. The second test is a broad picture test. It is looking at, you know, can you convince the USCIS that overall your view is that you possess something of extraordinary ability, all things considered. So in this criteria, you can talk about things that may not be listed in the 10, right? So the 10 may not cover everything, and you may have accomplishments outside of that. Or you may have an accomplishment of a different type, which cannot properly be described in those 10. Or maybe you meet like 6 out of the 10, but the 3 that you put in out of the 10 in that first part are the 3 strongest, but then there are 3 that you also additionally have, and you can make that argument in that second portion where you're talking about the overall picture. The reason that you have to pay a particular attention to this visa is that right now we're seeing tremendously long wait times for EB-2s and EB-3s, particularly for India, also somewhat for China. And so if somebody has, you know, an option to change from an EB-2 to an EB-1, you can actually port your priority date if you already have one under EB-2 or EB-1, so that you may even be able to get your green card immediately if your priority date is current. So let's talk about what priority date means, right? Priority date basically means the date on which your employer or you have filed an I-140 application that is successfully received. It's the date of receipt, okay? And so oftentimes what I see in my practice is that somebody has applied for a green card via EB-2, EB-3, and they have already secured a priority date based on their employment, but they're looking now at moving to a higher category of visa in the interest of saving time that it takes to reach their green card stage, right? So the first step is to get this EB-1A approved. That is via the form I-140. Once you have the EB-1A approved, if your priority date is current, meaning, you know, if you've looked at the visa bulletin and it shows that your priority date under the EB-1 category is current, then you can move to the next stage, which is your I-485 adjustment of status. So this is the broad picture overview of EB-1A. A lot more people, I think, qualify for it than actually take advantage of it. And there are many creative ways to apply for EB-1A. People sell themselves short all the time, and this is what I see, okay? I see people, like, for example, I had somebody who was a master's graduate in dentistry, and she did research in dentistry. She didn't think she qualified for EB-1A because she didn't have a PhD. That is a rumor and a myth. You do not have to have a PhD to qualify for an EB-1A. She did qualify for an EB-1A based on her research and based on the contribution that she has made, okay? The second thing that I see sometimes is that people think that you have to be in certain fields in order to qualify for an EB-1A. That couldn't be further from the truth as well. I had somebody in my practice who was a Bharatnatyam dancer. She didn't think she was eligible for EB-1A, but she was a highly accomplished dancer, and she used to teach dance. And we made her, approved for an EB-1A. And she was, in fact, she was married to somebody who was in the technical field, and she thought that it was only through him that she would be able to get a green card, but it turned out to be the other way around. He got a green card through her. So it's really interesting if you start looking at your work outside of the box and looking at your contributions outside of the box. One key thing you have to remember is that EB-1A is not only about your accomplishments, it is also about your impact, okay? The key word is impact. What impact has your accomplishments had on your company, on your city, on your state, on the country, on the society as a whole? You know, take it beyond, go global. You know, what are you working on and what impact could that possibly have in the future on the technologies we use, on our culture, on our music appreciation, whatever your field is, right? We also had a person who was a photographer who had a project where he used to photograph people in high-risk countries. So his goal was to show beauty in high-risk environments. And that project, even though that was not his line of work, was actually the ticket for him to get an EB-1A. So if you have a passion, then your passion may be your ticket to an EB-1A, okay? Then the second similar application is EB-2 National Interest Waiver. An EB-2 National Interest Waiver is similar to the EB-1 in that you're also looking at the overall impact, right? The impact to the nation of your work. And EB-2 National Interest Waiver is another one of those applications that you do not have to have connected with an employer. So you could actually apply for it yourself and qualify for yourself. And that is very unique in the US immigration system. Usually you need a petitioner. These are two exceptions where you can self-petition, okay? So that's EB-1A. I had a number of people who expressed interest in EB-1A, so I wanted to kind of delve into it in a little bit of detail. And I appreciate everybody's patience in asking, you know, specific questions because we have a lot of ground to cover. The next question is, you know, the next form of EB-1 is the EB-1B. EB-1B is specific to professors or, you know, researchers who are connected with a university. So this is not an application type that you apply for yourself. This is an application type that your university has to file on your behalf, okay? It is not the most popular kind of application. However, it's nice in the sense that, you know, the bar to obtaining it, if you qualify, if you're in that position where you're working at a university, the bar to obtaining a EB-1B is lower than the EB-1A. However, what I do find from my professor clients is that many of them have done tremendous amounts of research and they have done so much work in their lives. Basically, professors or researchers can apply for an EB-1B. What I said was that many times people, my clients often who qualify for an EB-1B also qualify for an EB-1A because they've done tremendous amounts of research. They've done a lot of work in their lives. Now, the thing with the difference between the two and how you choose is that EB-1B has a lower bar. So if you're not sure if you qualify for an EB-1A, but you are sure that you qualify for an EB-1B, it might be better to go for the EB-1B, right? Because it's employment-based. If you're in that field of employment, then absolutely that makes a lot of sense. But if you're someone who says, you know, I have a strong enough application for both, I can do EB-1A or I can do EB-1B. If you're someone who qualifies for both an EB-1B or an EB-1A, it may make sense to choose the EB-1A because it's not connected with your employer. It gives you the freedom to be able to change your position without, you know, too many hurdles. Okay, so that's kind of something that you have to sometimes make a decision about. Another time what I find is that, you know, people oftentimes qualify for like 2 or maybe 3 criteria out of the 10, and they may have a good EB-1A application, but they could make it stronger. So if you are familiar with the EB-1A, then you could treat it like a target, right? Like you could always work towards becoming eligible for an EB-1A if you have filed or if your employer has filed for you in a different category already. So it's definitely worth inquiring, even if you're not 100% confident that you are eligible for it right this second. And I've seen people who, initially came, they couldn't qualify for the EB-1A, or they weren't totally confident, but they made, 2 or 3 smart moves that qualified them for the EB-1A in a few months. Okay, so that is something that you can always aim towards, given the fact that the waiting period for EB-2s and EB-3s is so long for India in particular. Not the case for other countries. If you're from another country, you do not need to have EB-1A. You do not need to, if you're, unless you're from China, because China still has a little bit of wait, you do not need to worry about EB-1A. You could get your green card in the same amount of time with an EB-2 NIW. Or, if you're okay with your employer filing it, then with a regular EB-2 or regular EB-3. So let's talk about regular EB-2s and EB-3s. These are the most common kinds of green card applications based on employment, right? This is the standard. You work for a company. Your company is invested in you working for them. And so they want to keep you. Now, keep in mind, I'm saying they want to keep you, because this is an employment-based application that your employer files. It has to be your employer who files it. The law is very clear on the fact that an EB-2, EB-3 employment-based application, all costs related to those applications have to be paid by the employer, okay, including the attorney. It's very, very important, and it's a very sensitive topic if it's asked about specifically on the perm forms, and we'll talk about what perm is. But sometimes I have people asking me if they can have their employees pay for it, or if they're the employee, then if they can pay for a portion of it. Not the case for your employment-based green cards, with the exception of the 2 that I mentioned earlier. So that is important to note about EB-2, regular EB-2s and EB-3s, right? Employers have to pay for it. EB-3 is for someone who is, has a bachelor's level of education or lower, who is in a field where the employer can show that they couldn't find a U.S. citizen or a permanent resident worker to do that job who was minimally qualified. Okay, so this is the big hurdle with the EB-2s and EB-3s, which are not the case for the EB-1A and the EB-2 NIW that I mentioned earlier. For EB-2s and EB-3s, you have to make sure that your employer has to make sure that they're not able to replace you with a U.S. citizen or permanent resident worker. And the way that they do it is by conducting a series of different advertisements, okay? It's not worth me going into the detail of like what the series of advertisement are. This is something you absolutely need an attorney to help you with, okay? Because it's very specific in terms of where the advertisement has to be done, how much time the employer has to wait after the advertisement for resumes or, applications to come through. And it has to be, there has to be interviews done if somebody applies who is minimally qualified for the position. So this is a very sensitive part where, timing is really important. So it's very important to work with an immigration attorney when it comes to this advertising and the perm and the entire EB2, EB3 process. Okay. Then say the employer has conducted the advertisement according to their, according to the rules, and they haven't found any replacement employee who's a citizen or resident. They can move on to the next step. The next step is to submit an application with the Department of Labor. This application is commonly called the PERM application. It's sometimes also called the labor certification, okay? Please note, labor certification is distinct and completely different from an LCA. An LCA in the H-1B context stands for labor conditions application. That is not the same thing as a labor certification. A labor certification is also filed, however, with the Department of Labor, and it is a longer, much more complex application than the LCA is. It is LCA, you receive a response within 7 to 10 days. With the labor certification or the PERM, it takes several months, okay? So, and there is a chance if the employer puts in criteria for the job that are too tailored, too custom to the employee, then there's a chance that it can get audited. So, give you an example of what the employer is not allowed to do, okay? Say if the employer has a graphic designer from France that they want to apply a green card for. They're not allowed to say, we require the graphic designer to be able to speak French. Because, logically speaking, the ability to speak French has nothing to do with the performance of your work as a graphic designer. So they're not allowed to cheat that way and customize their job description specifically to the employee that they're interested in hiring. The idea behind these applications is that there has to be an opportunity to fill these positions by U.S. citizens or permanent resident workers. So the advertisement or the requirements for the position should be such that they logically fit the actual purpose of the job. So it's really important that how these job descriptions are phrased is very, very carefully, right? You can't say that you have an extremely high, uncharacteristic, requirement for an otherwise, different kind of a job. But at the same time, you don't want to say, well, I'm going to accept any and all graphic designers with any and all level of, experience, because that may actually not be true. You may actually need somebody who has, a certain number of years of experience. So it's a fine line, and you have to walk it with, an eye towards what's actually required by your job, your company, and definitely a conversation with the attorney about whether or not a certain requirement is acceptable. Then, so that's the PERM. Once that PERM is certified, okay, so the Department of Labor says, yes, that's good to go. Then it moves to the next level, which is the I-140. Now, the interesting thing about the PERM and the I-140 is that PERM is filed with the Department of Labor. I-140 is filed with the U.S. Citizenship and Immigration Service, which is the USCIS. Now, those two are with different agencies, and there are different sets of laws that are applicable to each agency. So sometimes in some cases, especially when we have EB-3 applicants who have a 3-year degree from their home country, sometimes we run into a situation where we have to say on the PERM that somebody is a professional worker, but we have to file, but we may have to file the I-140 for someone as a non-professional, or vice versa. So it's really important, to note that these may look disjointed, but that's because there are different sets of laws that govern the PERM part of the process and the I-140 part of the process. And this is the biggest difference between a regular EB-2 and an EB-3 is that EB-2, you need 4 years of bachelor's degree continuous and a master's degree. And your job has to require that level of education. That is the EB-2, right? EB-3 is you need a bachelor's degree, or you can also have an EB-3 for non-professional workers where, you know, maybe a certain type of technical skill is required, but not a full bachelor's degree. An example, sometimes I have seen EB-3 applications for people who are, you know, in a different kind of a field, like maybe a chef, right? Like a very high-end chef who has, you know, very specialized skills, but they don't have a degree that would be able to, you know, qualify based on their education. And so we can show that this is eligible for EB-3. Now, so that's EB-1, EB-2, and EB-3. And I've also gone over the EB-2 NIW. I think let's just, you know, instead of me just talking, let's actually break it, you know, down to the questions. So one of the questions I received in the responses that I had sent out was, does an EB-1 filing, this is very important, does the EB-1 filing conflict with an F-1 visa, or if the person is on an OPT? Can they, you know, conflict, right? The answer is sometimes yes. It depends on the timing, right? And F-1 is a visa that has a non-immigrant intent requirement. And when you file for the EB-1, you are claiming, you know, that you're interested in an immigrant application. So sometimes those two conflict. Now, there are ways to overcome the natural conflict. It depends on when your most recent entry under the F-1 was. It depends on what the wait time for the EB-1 application is in the meantime. And it, you know, whether you are intending on staying on F-1 the entire time, or whether you are intending to adjust status right away, or whether, you know, you're planning to switch from an F-1 to a different kind of a visa in, you know, the part where your EB-1 application is pending. So it's a very interesting question, and the answer is that it's a very complicated response, right? You have to customly work with an attorney very closely to make sure that the two don't conflict. That said, we've done a lot of EB-1 applications, EB-2 applications, etc., for people under an F-1 visa, so it's definitely not impossible. Somebody else asked me a very interesting question. Somebody wants to know, if they qualify for a green card, will they be able to work or study? I hope that I've answered that, because it depends on which level of the green card you apply for and qualify for. If you get an EB-1A and your EB-1A application is approved, and, you know, you are given your green card pretty soon, then you can work, study, you can, you know, basically do everything that a green card holder can do. But if you're someone who has applied for the green card application under a different field, maybe an employment-based field, then it has to be filed, like I said, by the employer, which means you can't just, you know, quit and like study or something like that without having some risk to that green card application. Somebody else wrote in, you know, I'm a novelist, poet, a certified U.S. poetry ambassador. You sound like you are right, perfect person to apply for an EB-1A. Published poetry, you know, recognized novelist. I mean, this is all the kind of information that the EB-1A is designed to be for. So definitely, I think, you know, if you are someone in any field, whether it's poetry, whether it's art, photography, dance, you know, science, engineering, medical, whatever, if you're in any of those fields and you've received some recognition that's a huge sign that you should look into the EB-1A as a possibility. Okay, well, this is a very time relevant question. How does the process for an EB-2 get impacted by the COVID situation that we have going on? And the reality is that, there shouldn't be a specific impact because the Department of Labor is supposed to be working. The USCIS is supposed to be working. The biggest change is the fact that we can't, at this time, do any in-person appointments. So, we're not doing biometrics or interviews. That's the biggest impact. But if you haven't started your application yet, you can absolutely get started on it. This is a really good question. Do I have to have an H-1B to qualify for EB-1 or EB-2? You don't. You can even qualify for these applications if you're not even in the country. So absolutely, you don't have to have any specific kind of visa to qualify. I didn't go into EB-1C yet, and I did see a question about EB-1C. So I do want to go into that because that is a very interesting option, and it's sort of a workaround to some of the EB-2, EB-3 challenges that we see. EB-1C is a green card application for a manager or an executive of an international company. Okay, what does that mean? It usually comes, for most people, it comes after they have an L1A. They have an L1A, which is based on their managerial or executive experience in their home country for the same company. That company has a branch in the United States, and they've come to, as a transferee, to the new branch. They can qualify for EB-1C. That's the third category of EB-1, right? Like we went over EB-1A, we went over EB-1B. The third category is EB-1C. And so that is what the EB-1C involves. Also, a way that EB-1C is used to sometimes work around is if you're working, say you're working in it as an H-1B or an OPT or something like that for a multinational company, and your company has a branch in Canada or Europe or Australia or India or anywhere, right? And you're okay with going and working as a manager in that branch that is overseas for at least a year. If you do that, then after you come back and you're working as a manager over there and you're working as a manager in the United States, then you can apply for and qualify for an EB-1C upon your entry. So as the EB-2 timelines have increased tremendously, what I've seen is that, sometimes people are opting to do EB-1C as a workaround so that people have the opportunity to switch categories in the EB-1 without needing to have, the special qualifications that are required for EB-1A. The big difference between EB-1A and EB-1C is that EB-1C is sponsored by an employer. So you don't apply for EB-1C by yourself. You apply for it through an employer. So that's a big difference. And you have to have, 1 year of experience overseas. As long as you're willing to, you're working at a multinational company, you're willing to sacrifice a year of being in the United States and going abroad for a year, you come back in the United States in the managerial or executive capacity. Executive capacity, usually if it's your own company, right? Usually for like larger companies, it would be a managerial capacity. So if you come back in a managerial capacity, say, and you were in a managerial capacity for a year overseas as well, then you can apply for an EB-1C. Not you, actually. Your employer can apply for you as an EB-1C. So that is a workaround for people who may not have, the extraordinary qualifications that are required for EB-1As, but want to be able to classify themselves under the EB-1 category in the interest of getting their green card sooner. So yes, if you've been working for an employer, you've been managing employees, or you've been managing a function, because even functional managers are eligible, and you are willing to go overseas, manage employees or the function from overseas for a year, and then you come back to the United States, your employer can apply an EB-1C. So that's a really good option for a number of people. Stimulus checks, and what impact will they have on the green card application because of the public charge rule? Stimulus checks are okay. It's unemployment that sometimes becomes problematic, because if you're on an H-1B, for example, and you're receiving unemployment, that means that you're not actually in status, right? Because in order to be an H-1B, you have to be full-time employed. So that's a conflict. But if you get your $1,200 or whatever stimulus amount you qualify for, that's perfectly fine. There's no impact on your green cards from that. Okay. Somebody else asked me, EB-2 priority date is 2016. Can I go to the home country and come back when the date will get current? Yes. This is the exciting thing about green card applications, is they're not connected directly with visas. So you can have a green card application. You don't have to be in the country. You can come back when your green card application is current, and you can process at the consulate instead of doing an adjustment of status, and get inside the country that way. So absolutely, that is possible. And another, what happens after the employment-based application is current, or what documents are needed? You need to be able to show that you intend to work for the employer who has filed your application, right? So say you're working for company A. Company A filed your green card application, but there's a waiting period, or your priority date is not going to be current for another 12 or 14 years. And then you switch to company B. Company B said, I'm not going to file your green card application, but I'll do the H-1 transfer. So you applied for the H-1 transfer. And then you switch to company C. And company C said, yes, I will apply for your green card application. And luckily, when company C finished the application for your green card, I-140, then your application became current. That's perfectly okay. You're working at company C. Company C has filed your green card application now. They have taken the priority date from your original application with company A, but company B didn't file any application at all. That's also acceptable. Okay, so you just need to have an employer who has filed your application, whom you intend to work for at the time your application is current. That's important, okay? And your initial application is important, because that gives you the priority date. That puts you in line for it to become current. So that's something that we see mostly for our Indian nationals, because there's such a long wait that they can go from company A to company B to company C and not have every step along the way apply for their green card. But keep in mind, every step along the way does have to file your visa, because your visa is not connected with your green card. And green cards, you can apply, your company can apply for you, or you can apply for them. You don't even have to be in the US when you do it. Okay, can I come to the US and then find an employer who will take over the green card? Yeah, you can. But you need to come to the US on some kind of a visa. So that's the first step, is, how will you come to the US? If you come as a B2 tourist employee, and then you find an employer who's willing to apply for your green card, that's perfectly fine, but you have to make sure that you're not overstaying. If you overstay, then your green card application is unlikely to be successful. Okay? I'm going to go to some of the recent questions that people have sent me. So can a green card application filed in EB-2 be converted into EB-1A? If yes, will it have to be done by the same employer who filed it? I hope I've covered this. EB-1A does not have an employer requirement, so you can file it, convert it yourself. If you're eligible for EB-1A, you can take that priority date from EB-2 and port it to the EB-1. But this is not an employer-based application. So I guess one question I would ask is, what do you mean by convert? It doesn't convert. You actually have to be independently eligible for EB-1A, and then you can move the priority date from EB-2 to EB-1A. Okay. And no, it does not have to be the same employer who filed it. Current processing time for EB-1A for Indian citizen. I should have known this, but I don't. So give me some time to actually see that. You can also look it up on the visa bulletin yourself if you know what the visa bulletin is. Okay, so we're looking at EB-1A for India. Right now, I see 2015 as the date that is current, which means we're looking at around 5-year wait for receiving the green card. But it's 2017 for applying for the adjustment of status based on that, because now there's 2 different charts for the visa bulletin. I know this is a little confusing, so if you're seriously thinking about applying, you have a question about timeline, definitely schedule the consultation, and it'll definitely be worth your while. Okay, this is a good question. For EB-2, where does the prevailing wage determination process fit? Is it before the perm, in parallel to the advertisement, or when? So prevailing wage is a really good idea, but it is technically optional. That is why I didn't cover it in the required step, but mostly even I usually do prevailing wage when the time permits. So when I usually like to do it, depending on how much time there is to the 6 years of the H-1B, or what our timeline looks like with the employer, is I like to do it first. I like to do the prevailing wage first and get a response from the Department of Labor as to what the prevailing wage minimum should be for this particular employee, because ideally I like to put it in some of the forms of advertisements as well. So it doesn't have to be done. You could, like an LCA, in the LCA, we usually don't do a prevailing wage request. We usually just calculate the prevailing wage ourselves. You could calculate the prevailing wage with perms. Not the best idea, though, because perms take so long, and you definitely don't want to have calculated incorrectly. Any update on removal of countrywide cap? Very, very good question, and one that I really wish was taken more seriously. There's a lot of political discussion around what to do with the long processing times. However, there is not an agreement on how to address it. And with the politicians and the political situations, everything is connected with elections, everything is connected with political will. Unfortunately, there hasn't been a recent update with the COVID situation. The political will has not been there. So there was a very sincere discussion, and there were bills proposed, and there were senators, including our senator here in Illinois, who proposed a different version of the bill, that were extremely interested in doing this, and then everything kind of went cold. So that's unfortunate, but I hope that it does get picked up, because the wait times we're seeing are crazy right now. Yes, I have a question from somebody that says, I have 12 years of experience. I'm working as a human resource manager in India, and I want to know if I'll be eligible for any of these categories. I'm planning to apply for the student visa. So if I'm on the student visa, will I be eligible for this visa category? Yes, you can. You can apply for a student visa, but based on your experience and based on, possibly your education, it sounds like you should be eligible for at least an EB-3. And so, you can, if you have an employer who's willing to do it for you, even if you're still a student, you can have the EB-3 application filed by an employer, okay? So back to the example that I gave, somebody asked, so the company C has to take over the priority date before it becomes current. And this is, I'm guessing, referring to the example that I gave earlier about company A, B, and C. And B doesn't have to file an I-140 if it's not current, but if the application is filed by C and the I-140 becomes current, then yes. But the question, I think, is, before the priority date becomes current, does the company you're working at that time, do they have to have an I-140 filed for you? So permanent I-140. Yes, yes, yes. Unless you're planning to work for the original filing company and you can convince the USCIS that that is your intention, you have to have the company you intend to work for, upon receiving the green card, have a green card application filed for you. So employer is delaying green card because of COVID. Is it better to switch, or how much time does it take from end to end with the EB-2? I think that depends on, the country. But if you're talking about India, it takes a good amount of time from end to end, if you mean by the time you receive your green card. But if you mean by the time the I-140 is filed, you want to give yourself around a year to be able to complete, the process, even with like premium processing the I-140 and, trying it as soon as possible. If you're wanting to be safe, you want to give yourself at least 1.5 to 2 years to complete the EB-2 process. Is day one CPT a risk to EB-2 process, and how to avoid that risk? Okay. Day one CPT is a risk in general, in visas in general, because they look at intent very carefully, right? So if you're receiving day one CPT, do you have intent to learn, or do you have intent to work? Because CPT stands for curricular practical training. Key word is training, right? So if you are in training, are you actually doing it for the purpose of furthering your education? And are you attending your classes? Are you participating in the examination structure? Are you participating fully in your school? So that's important in terms of intent, not just for EB-2, also for H-1Bs, and also for every other kind of visa or green card that you may qualify for eventually. So it's really important. If you are in a situation where you are needing to do day one CPT, it's not always undoable. So it is doable. And I've seen a lot of my clients be able to do it. But it's really important to make sure that you can prove that it's training. Make sure that you can prove that you're learning, right? And how can you do that? If your employer has a formal training program, then that's the best case scenario, right? Like, okay, you have it, you're going to be working from, this is your schedule, you're going to be interning at this location, and that CPT location is going to have a program where you will train, go through a certain kind of a training, go through a certain kind of evaluation. You're supervised, right? That is the intent behind CPT. It's like an internship, right? It's not supposed to be like work. So as long as you can show that it is learning, it's connected with your education, and that you are fully invested in your education, then the EB-2 process or EB-1 process or EB-3 process or H-1 or whatever will have minimal risk of being impacted. If I-140 is applied and pending, can you leave the country? Does the I-140 become invalid? Can it be applied from India? Yeah, you can apply from India. You can leave the country. I-140 is not going to become invalid because I-140 is a future application. It is an application for the future employment, not for your current employment. That's why it's completely distinct from visas, right? Visas govern your current employment. Green card applications, employment-based green card applications, they govern your employment upon receiving a green card. So you're not, the claims, the forms that you're submitting for the I-140, the employer submitting for the I-140, they're not indicating that you're working there now. They're indicating that you will work there when you are approved. So yes, you can apply for it from any country. Okay. The stimulus checks do not count as public charge. This is to stimulate the US economy. They're intended for people to spend. They're not intended as a public charge expense, right? So definitely no. You're okay to receive stimulus checks. No risk from that in particular. So, somebody asked me, if I apply for an EB-1A, while being on an F1 visa, will that influence my OPT application because it's being assessed by the same adjudication office? I was thinking, how many years will it take for me, an Indian resident, to get a green card after getting my OPT in hand, and then file for the EB-1A and wait? What about the family status? So I'm guessing what you mean by the family status is a family-based application for green card, and whether that impacts your OPT or not. Yes and no, right? Yes, because F1 is a non-immigrant intent visa, and OPT is a part of an F1. No, because, like I said, all your applications for green card are future applications. So conceivably, even though it's unlikely, right, but conceivably somebody could have temporary intent for now and eventually want to move permanently into the US. So that's how you have to treat it, is that the intent for now is temporary, but eventually I want to be permanently in the US. And because these are two different time frames, the intersection of time, the span of time in which you apply, those are key factors. It is safer for sure to go on H-1B first. It is safer, okay? However, it's not always possible, and you can apply for an EB-1A even if you're not in the country. So, if that is what it comes down to, work closely with an attorney and make sure you're careful in making it happen, but you can make it happen. Leave for good until you hear back on the approval of the I-140 and the dates become current. Yeah, you can, right? Because this is an application for the future anyway. I-140 approved with employer A, currently working with employer B. If I go to India for good, what will I need in order to come back, and when do I have to come back? So if you go to India for good, I'm assuming that means until your I-140 is current, the employer A I-140 is current. Yeah, you can go back. And when your employer A's I-140 is current, you will need to have proof that your intention is to work with employer A. That is because that is the only employer so far who has filed your I-140. If that is not your intention, if you want to come back and you don't want to work with employer A, then you need to have a different employer file your I-140 and perm. Okay, but assuming you do want to come back and work with employer A, you'll have to have an offer letter showing that you intend to come back and work with employer A. If you're working with that employer in a remote office, overseas office, then paychecks, pay stubs to show that you have been connected with them somehow. You will have to show your past immigration records, including your I-140 approval notice, and your passport, and a number of other documents that will be sort of dependent on the situation at that time. But the key thing is that you have to come back and prove that you're able to, willing to, and have a position to work for the employer who filed your original I-140, unless you have another employer whom you intend to work for who also files a perm and I-140. Okay? The I-140 cannot be transferred, correct? They will not transfer an I-140. Only the priority date is transferred. So any new employer does have to file a perm and I-140, because the whole premise of the perm and I-140 is that that particular employer is claiming that they need you because they are not able to fill the position with a U.S. citizen or resident worker. So they're claiming a business need. That's the reason why Your I-140 cannot just be transferred. Your priority date can, but your I-140 cannot be transferred. Okay? Final thoughts. I just want, to convey, please respect everybody's privacy on here. We do not have attorney-client privilege. Advice that I've given you today should not be considered, legal advice. And the reason is because this is just a brief call based on brief amounts of information that I've answered your questions. I'm happy to give you legal advice. If you call and schedule consultations, we'll give you information about how to do that. And, so definitely feel free to expand on your questions and get specific advice if you're interested in any of these topics that I've covered today. Okay? Thank you, everyone. And I hope that this has been informative for you and it's given you some food for thought. I look forward to touching base with anybody who contacts us with other questions. Otherwise, best wishes to everyone. Stay safe, stay healthy, and have a great weekend.